one case on the docket this afternoon. Going to tell you before, but don't take advantage of it. I'm going to give you a little bit of leeway on the clock this afternoon. It's an important case, and we want to ask all the questions we need to ask. So,
thank you, Your Honor.
You may proceed whenever you're ready, counsel.
Thank you, Your Honor. And I would, wherever you decide, Your Honor, respectfully, that I'm within 5-6 minutes of what you're going to give me, I'd like to reserve at that point, since you didn't give me an express time on that. I'm David Sales, Your Honor. I'm here with Dan Hoffman, and we represent.
Okay, I'm going to ask that you try to speak up a little bit.
Maybe I'll lean into the mic a little. How's that, Judge? Is that better?
Yes.
I'm David Sales. I'm here with Daniel Hoffman. We represent the appellant and the plaintiff in the trial court, Susan Snyder. We're here, as Your Honor know, seeking review of the trial court's order in this case. The trial court's order did two things. It granted a motion for summary judgment that was filed by the prepaid board, which disposed of the action when it was granted in its entirety. And there was also, and we're going to start with this if we may, an independent motion for partial summary judgment that was filed by the plaintiff, which sought an order confirming what the board had admitted in its answer, that the contract that governs this action is the contract that was signed by my client, the 2003 to 2004 Master Covenant. The motions were interrelated, of course, but I'd like to focus on that issue first. And more specifically, I would state it this way: the trial court's conclusion that the board is empowered to serially amend the parties' agreement and alter its substantive terms so that whatever form the board is currently using, and it is contained in an administrative rule, which is...
What if we find, if we agree with the trial judge, that this is unambiguous, and that it clearly talks about, or at least that the statutes and the rules can amend it? And let me try to break through and tell you where my question's going. It seems to me that if we hold that way, there's a good argument that this contract is illusory, because what you were purchasing was the right to have the child sit in the classroom, basically.
Right.
And I'm going to throw this out to the other side.
And it's sort of, I mean, I'm sorry.
But did you really raise the fact that there's no contract, or this is an illusory contract? And the other part of that question, I'm sorry for keep on piling on, is if you did raise it, what would the remedy be?
That's a great question, Your Honor. I think it's got multiple parts, and I'm going to try, as I remember it, to break it down if I would. The first point, of course, is that we would like to try to convince the court on the issue of ambiguity. If you start with the preamble to the contract, that the contract's preamble, which is really what they rest on to be able to assert that there is this power to alter substantive rights in the contract. Our position is twofold. First of all, well, it's really threefold. Our position is that that contract is ambiguous because, in the first place, it refers to applicable statutes and regulations, and then goes on to refer to the Internal Revenue Code, Section 529, which is the umbrella law that allows for the creation of plans like this and other types of plans with which all of us are familiar. This particular contract, the 2003-2004 agreement, has provisions in it that reference the statutes that are in play, some of them, and the regulations that are in play. And one reasonable interpretation, certainly it's at least ambiguous, we would submit, on that issue, is that the applicable statutes and rules are the ones that are referenced in the contracts. There is no means otherwise by which someone occupying the court's role, in this case, can determine what was applicable and what was not applicable. We would assert that the contract is further ambiguous for other reasons.
Okay, well, so let me understand. The first argument here is because it uses the word applicable, this is an ambiguous as to which statutes can be amended and applied to this contract.
Right. What is applicable? There's no direction. We know that certain ones are applicable. In fact, if you move to the very next section, which is application, application 1.01. Application means the application form adopted by Rule 19B 4.001 in Florida Administrative Code. If you move to we know that's applicable. If you move to the very next section, it refers to the definition of beneficiary and incorporates by reference the statutory definition of beneficiary, referencing the statutory section expressly. We know that those are applicable. We would submit to your honors that there is no way for anyone to determine who's reading this contract what additional statutes and regulations are in fact applicable. And one of the principles that comes through in the cases that are cited by both parties is there has to be some definiteness, if that is in fact an appropriate word, to what it is that's being incorporated. And we would submit that with that respect to that provision standing alone, there is no definite quality to it. But I would add that it's important.
Okay, I'm going to push you ahead a little bit. Well, you can get back to telling me why this is ambiguous in a second.
I'm sorry, Your Honor?
You can get back to telling me why this is ambiguous in a second, but I want to focus for a second on if we do not buy your argument and we agree with the trial court that this is unambiguous and they can amend it, including the substantive portions of the agreement. Does this contract become illusory?
Yes, we would take that.
And where does that lead us?
Where it leads us, that's a really great question. Where it leads, Your Honor, I think, is back to basic Hornbook principles of contract interpretation. Is there a means by which this contract can be interpreted so that it is not illusory? And I think that it is. I think that there is such a construction, and obviously the court is duty-bound to avoid a construction which would render the contract illusory. But you're raising kind of a separate and independent point. We did not seek rescission of the contract. We did not.
Okay, that's what I wanted to clarify.
Right,
You're not seeking rescission of the contract. You're not seeking money back, interest.
Well,
I mean, that's not the remedy you sought, is my understanding. I mean, you want the remedy of the tuition,
right.
I mean, whatever differential fee, I'm sorry.
Right, the sum total of what would be paid if tuition differential were properly, and we believe it should be properly considered part of tuition. But I wanted to go, and I don't know if that answers the court's question. I mean, we were seeking money damages for Mrs. Snyder for what she was told.
But the money damages you were seeking was not your original amount plus interest.
Correct. Because actually, Your Honor, according to Judge Cooper's order, we're not entitled to that. What we're entitled to...
I know that you're not entitled to it, but I'm trying to find out
right.
that he said you're not entitled to it, but I'm trying to figure out what you...
The only way that you get your money back in full with an investment return is it's specified at the end of the contract, and this carried through actually from the first contract to the most current one. The only circumstance under which you get your money back plus an investment return is if the state cancels the program. Absent that, the same provision of the contract.
Okay, if we say there's no contract, if we say this is illusory and say there's no contract, you're not governed by the contract. What would you be entitled to at that point?
We would be entitled to, if we had pled it, which we had not, would be rescission. But
okay, and you're not asking for rescission?
We did not plead rescission. But I would like to reemphasize again, the parties have argued both sides, and we put this in order because it's sort of the legally logical order in which to order the arguments. We put the position first that the contract was not ambiguous as to the word tuition, because tuition has a commonly understood meaning, and that there is a route by which Your Honors could find that the contract is unambiguous and fine for us, and that's fully set out in the briefs. But I would urge the court, having thought quite a bit about this, to take a...
But to get there, don't we also have to say that any rule that the state adopted that changed the word tuition or changed the definition, how would that not be applicable? I mean, it would be applicable to the contract. I mean, because your first argument is we're not sure what applicable is.
Well,
But to get to where you're going,
right, but that wasn't the only reason that I think that the preamble doesn't get them. If you take a look at this preamble, the language in it, what is it really trying to do? And there's an analog to it in the statutes, and the parties haven't cited it, but reading it, our position, I would argue to the court should consider, what is this provision trying to do? Is this provision really trying to preserve to the state of Florida, which has guaranteed some kind of investment expectation, taken money from citizens, promised them a return so that they can squirrel away money for college and put the risk on?
This is an investment plan.
It is not an investment plan as that is defined by.
This is a contract where I can take advantage at the young age of my child to lock in a rate.
Exactly.
This is not an investment program, correct?
I agree, but it is a contract, and we could spend days talking about the concept, which we're taught from the first day of law school, about what it is that we're supposed to be doing in this setting. But one of the things we're supposed to be doing is trying to ascertain the intention of the parties. And whatever label is given to it, and I agree, because there are pitfalls if you call it an investment contract. I agree with that, and I'm not making that argument. What I'm trying to suggest to the court is one thing that we know about the allocation of burdens and rights under this contract is, the one thing that we can say for sure is who, as between Mrs. Snyder and the state of Florida through the prepaid board, accepted the risk of an increase in the cost of tuition. And the party, there's no question about that. Whatever spin either side wants to put on the interpretation of this agreement, there's only one side to whom that risk was allocated. And what has happened?
If obviously this is an administered program, and it's reasonable to assume that there are going to have to be changes made in administration, whether it's arguably a procedural rule or arguably a substantive rule. So if I accept your position, does that mean anytime there's even a remote substantive change made, that all the parties have got to come back down to the office and re-sign the contract and rewrite and start from scratch?
No, and I agree with you. And what I was about to say in response to one of Judge Wolf's questions is, if you look at that preamble, what is it for? And I think the analog to understand what it's for is actually contained in the statute. Because the statute in the beginning and now, and it's 1009.9716, and this is in the section relating to the powers of the board, because that's really what we're here on. What it does, subsection 6, it specifies that the board has the power to make sure on a going forward basis that these plans are in compliance with part 529 of the Internal Revenue Code. And the reason for that is obvious, because nobody wants to be standing in a situation where there is, I will call it a return, because there is obviously some return involved when you have one of these contracts, because the value of it increases over time, because tuition has increased over time. And nobody wants to be standing in a position where, because of changes in federal law, suddenly, because of changes in the securities laws or changes in the IRS code, suddenly somebody is socked with some kind of obligation that nobody foresaw. That's the purpose, I submit, of a provision like this. That's the purpose, that's the reason that the legislature conferred upon the board the power to make changes that conform with changes in the governing law. Both sides, and this is in the parties' papers below, and it's actually in Judge Cooper's orders as well, and the board conceded this at page 146 of the record, that there has to be some limitation on changes in the value of what it is that was sold to Mrs. Snyder.
And how is it, I mean, as succinctly as possible, how did she not get what she bargained for? She's never been asked to pay this, or her son, this TDF fee.
Right.
When she entered into that contract in 2003, it said 120 credit hours.
Right.
She got 123 credit hours. So
what
did she not bargain for?
Well, that's really, I mean, if you accept that she has been provided with what she bargained for, then the case really comes to an end at that point. The point that we're trying to make is,
okay, I'm going to interrupt. Because the next question I was going to ask, and I think it's appropriate now, what exactly did she bargain for in 2003?
She bargained for, in contractual terms, a tuition plan, which was defined as the registration fee. It's 1.08 of the contract. That means tuition, which includes the matriculation fee, expressly stated, that has been eliminated in the current contract. doesn't exist anymore. They have abandoned that. Financial aid fee, building fee, capital improvement trust fund fee. And then it goes on to say, with respect to tuition plans, the purchaser prepays 120 semester credit hours of tuition at a state university. Now, this is where...
Now that you've said all that, and I'm going to ask the other side of this, isn't what she bargained for the cost of my child sitting in a classroom for 120 hours of credit?
Right.
And whatever that cost is.
Yes.
Is that the bottom line?
That's what she bargained for, and if she doesn't pay, if she did not have one of these plans, obviously, and I know that's the rub, anybody who attends one of the universities in the state who doesn't pay that fee can't matriculate. And I don't think it's an accident that the matriculation fee, and Judge Cooper, if you look at the transcript, sort of struggled with that because...
Can she, for the amount of dollars, the value, can she today, could this child sit in Florida? The answer, without the exemption that's given for people that got the contract prior to 2000.
If she has a contract or if she doesn't have a contract?
Okay. I'm sorry, I kind of lost my train of thought, but
right.
I'm trying to figure out, she bargained for the value of what it would cost for somebody to sit in the classroom in the state of Florida.
Correct.
That's your position, without all the gobbledygook.
Well, yes, but if you calculate what the value of that was at the time she entered into a bargain with the state, that was something that included everything that represented tuition, including the matriculation fee, which they have eliminated from their contract, included the registration fee. It included everything, to paraphrase what Your Honor said, that someone needed to pay in order to obtain 120 semester credit hours. And now, you cannot matriculate at the state of Florida. You cannot sit in those classes unless you pay that fee. And the significance of that is, because we can all see from the record that what the state did was just shift part of that total cost to something and call it a different fee. The value of what she has lost, as we show, at least based on the example that was given in the trial court, is 20% of the total of what should be paid to this particular contract holder. And I don't know if that answers...
Judge Cooper held that there was no material breach.
I'm sorry?
Judge Cooper held there was no material breach of this contract.
Right.
Reading his order, it's unclear to me. He says there's no material breach because the state had the right to amend it, or there's no material breach because you really got pretty much what you asked for. Did he hold both, or?
I think you can read the order, either way, but I mean, all of these things, and I'm not fussing with Judge Cooper. I've appeared in front of him before in another case. He's an excellent trial judge.
I'm not taking anything you say as attacking.
And as we all know, that he didn't write this order, which is fine, and we're not arguing that Your Honor should look at it any differently because it was prepared by counsel. I'm very familiar with those cases that teach otherwise. But what we do know is that something that was proposed to us prior to the time that we entered into a contract is the value. If we are not attending college in Florida. We are attending college out of state. And what we purchased, to finish up the question that I was asked just a few moments ago, in addition to a tuition plan and a registration fee, what we purchased was the right and the privilege to use the value of what it costs to attend universities in Florida to an out-of-state institution. And I don't want to be critical of the trial court, but he did seem to be influenced by the fact that the state has some kind of greater interest in protecting people who participate in state. This contract doesn't create that kind of right or privilege for persons in state versus persons out of state. And what happened is... Okay,
yes. And I had a reason for asking the question of what he held was a material breach. Because it seems to me that if he held the contract, gives the state the unilateral right to amend anything.
Right.
That's a question of law. Definitely reviewable. That's right for summary judgment. Right. If he held the material breach was because you got pretty much what you asked for, does that become a question of fact that is not appropriate for summary judgment?
I think that yes is the answer to that, but I think yes for other reasons, owing largely to the fact that there is an ambiguity in the contract. And the state has, the board has responded that there's some kind of expertise associated with the administration of this contract and deference is owed to them. We disagree for the reasons that we cite in our brief. And on that, in that regard, one of the things that I really wanted to share with the court today, because it's part of the preparation, if you look at these contracts and you say, if you ask yourself, if you hold them up, particularly the provisions that allow clearly in the new contract for serial and substantive amendments, and those are contained in sections 1103 and 1123 of the contract. Another important change, if I may, is that in the first contract, in the earlier contract, there's a requirement that changes to the contract have to be signed in writing and signed by the plan holder. That's in the first contract. They eliminated that in the subsequent provision. But this is a really important one that I would like to share with the
I'm going to interrupt you because your time's running, and I want to ask you a question. This is our time, not necessarily yours.
Yes, sir, Your Honor.
The impairment of contract, did Judge Cooper ever specifically rule on that?
I don't think, I mean, it was certainly argued in the trial court. I'd have to look at the order and see if it was discussed specifically. We certainly made that argument. It's in our pleading. It was argued in the transcript, and we've certainly raised that issue on appeal.
Okay, and the reason I'm going there is it says if he held that there was no material breach and you pretty much got what you wanted, that would be an implied ruling on the impairment of contract argument.
I think that would be a route for Your Honors to review that issue specifically, yes.
Okay.
But I think it's reviewable anyway.
And it seems to me that arguably a lot of the impairment of contract question would be a mixed question of fact and law.
Which again would require...
But in the Searcy case, the Supreme Court seemed to rule as a matter of law that there was an impairment of contract in that particular case.
Right.
What I'm trying to get to is, can we look at the impairment of contract here without it having been looked at by the trial court?
I think because the case is presented to the court on a review of a motion for summary judgment, the answer to that question is yes, because even if it were a mixed question of fact and law, and let's remember that in the Searcy case, we had an act of the legislature that was being reviewed that didn't contain the ambiguity. They were very explicit about what the issue was in terms of denying the right to collect an attorney's fee in the legislation that was the subject. There was no question about what the legislature was trying to do. So that does distinguish it a little bit. But I do think that if Your Honor believes it's a mixed question of fact and law, and there are facts that remain for the court to, the trial court to resolve, that would be another basis. I don't know how much time Your Honor is going to give me, but I did want to say one thing before I sit down, if I may.
You may.
I would ask the court, when you consider whether or not we are really bound by these serial amendments, to look at section 1110 of the current form of contract, or at least the one that was current at the time we were before the trial court. It requires that any claim alleging a breach of the parties' agreement be brought as an administrative proceeding pursuant to Chapter 120 Florida statutes. In other words, the contract that they say that we're bound by purports to forbid legal action in the circuit court, eliminate jury trials, and substantially limit the standard of review if we were coming here after having concluded an administrative proceeding. It also means, and these very fine lawyers on the other side of this case didn't miss this, it also would mean, and I'm not making this argument, that there was no jurisdiction in the circuit court for this. I'm just giving that as an example to show that there is no possible way, most respectfully, that the court should or could conclude that serial amendments through administrative rulemaking that change substantive rights, like the right to sue.
Okay, what I'm going to do now is I'm going to cut you off. I'm going to give you 5 minutes for rebuttal.
Yes, Your Honor.
Give the other side 28 minutes on their side to argue.
Thank you, Your Honor.
May it please the court, my name is Mike Riley. I'm here with Florida Prepaid College Fund. With me is Michael Frick, who's the Director of Operations for the program. Judge Wolf, Mrs. Snyder received everything that she contracted for.
Okay, going to be my first question out of the box. What did she contract for?
In the tuition plan, and Judge Thomas noted this, in the tuition plan that Mrs. Snyder purchased in January of '04, she purchased 120 credit hours of registration fees. Appellant was correct in saying what those, what consisted of the registration fees. Registration fees consist of tuition. At the time, it was called the matriculation fee. That was changed by the legislature in '02.
Okay, well, help me here. I read this contract, and forget about matriculation and all this other stuff. I read this contract that I'm buying the value of putting my son or daughter's seat in a chair where they're going to get 120 hours and the value of that. Why is that not right? Why isn't that not a reasonable reading of all this gobbledygook?
And Judge, excuse me, it is reasonable as far as it goes. But, and let me just back up. I think it's a little bit of a red herring that we've spent so much time today devoted on whether the '03-04 master contract applied or whether the '16-17 master contract applied. We have expressed in detail why we believe the board has the authority and the capacity under this program to provide for changes in the master contract through the administrative process.
Okay, if I understand what you're saying, but if I'm right in what this person reasonably thought they were going to buy, my question to you is, if you could change that, what they really wanted to buy, what was the substance of what they wanted to buy, was there really a contract here?
Your Honor, with respect, let me back up and say that whatever the concept that she was buying the cost of college through this particular tuition plan is belied both by the contract in '03-04, by the contract in '16 and '17, and by Chapter 1009, which provides for the Florida Prepaid College Fund. Let me call
okay, what in '03-04 first?
Let me call it to your attention, Section 9.01 in the '03-04 contract. Additional fees is the heading. State universities and community colleges may charge fees in addition to tuition, local, and dormitory fees described here. The beneficiary will bear the cost of any such additional fees, including but not limited to application fees, laboratory fees, meal plan fees, and security deposit. There is similar language in the 16-17 contract, except there is a specific reference there, of course, to the tuition differential fee.
But under your position, because I think I understand your position, but under your position, my question comes at that point, could the state of Florida never raise what they call tuition fee? Never, I mean, just never raise it. Come up with, you called it tuition differential fee here.
And that's what it's called.
But just say, okay, the fee to sit in the classroom fee.
It's a defined fee. It is in the statute, what the tuition differential fee is and what it provides.
And never raise the tuition ever again. And under this, you're reading this contract, every raise in fees is going to go into that new category that we just had. At that point, if the state of Florida could do that, what is this person purchasing at the beginning?
What you're suggesting is a bait and switch operation, which
smells a little bit like to me.
Which is clearly not the case here. And this goes back to your initial observation of why this was not an illusory contract. And appellant was absolutely clear in the remedies that Mrs. Snyder has sought in this action. Mrs. Snyder has received the redemption value of 120 credit hours of registration fees that her beneficiary, her son, has now used at the Citadel.
Did she get the value of the entire cost of her son? I understand you have all these other fees. academic fees, parking fees, but did she get the full cost of, forget about any other service she got, did she get the full cost of having the ability to have her son sit in that classroom, son or daughter, sit in that classroom for 120 hours of credit?
She got what she contracted for. There was never a representation in the contract that all the cost of college would be paid for. And that is
No, not all the costs, but costs
Well-
that are associated with just sitting in the classroom.
I don't know how you separate that. There is a cost of going to college that, that involves a number of things. Your Honor, if you look at 1009.24, there are probably 20 fees
So you're telling
identified
me
there.
the bottom line, I'm sorry for interrupting, but I'm just
No,
trying
no,
to,
of course, Your Honor, no problem.
I'm just trying to get this straight in your mind. You're telling me that the state of Florida can set up another account, let's just call it tuition fee 2. Move that money, not move the money, but any additional cost, put it in that account, never raise with the original tuition fee. And anybody that wants to send their child out of state, even though you said child out of state, you're only going to get what the tuition fee was from the day one when you signed the contract.
You will get what you signed up for at the time. Now, remember, Your Honor, things have changed since '07, since the TDF was enacted into law. Mrs. Snyder, in January of '04, when she purchased her tuition plan that provided for, once again, 120 credit hours of registration fees, which the redemption value of that has been provided to her to go to the Citadel, her beneficiary, her son. At that time, there wasn't a tuition differential fee. The tuition differential fee was established in '07 by the legislature. At that time, the legislature did two things, fundamental to, I think, speak to the concerns that you're presenting here in your questions. First, with respect to all the pre-07 account holders, the people that purchased a plan, a tuition plan before '07, they charged the universities, not prepaid, they charged the universities and told the universities could not charge that tuition differential fee to those pre-07 account holders. That's one thing to address the concerns.
No, I understand that, but I'm talking about the out-of-state.
And the second thing that the legislature did was then to allow purchasers, account holders, to purchase tuition plans which included the tuition differential fee. So going forward from '07, there's been some variances as to how those plans have been made available to prospective purchasers. But since '07, a purchaser of a Florida prepaid college fund tuition plan under various plans has been given the opportunity to add a tuition plan, which includes the 120 hours of credit hours of registration fees we've talked about before, plus to have an entitlement to receive the value of the tuition differential fee when their beneficiary goes to school.
But in this
university.
case, in order to counter any detrimental effects to those who had already purchased a tuition plan when the TDF went into effect in '07, it's very clear that it said this TDF will not apply to previously purchased or those in effect at the time. So that accounted for any detrimental effect on those who had bargained previously for a contract, correct?
Yes, ma'am. And that was consistent with what the entire plan and the entire program was meant to do, was to allow Floridians to plan for the future. With respect to the tuition differential fee that was enacted in '07, the legislature, I think, and I'm not here for the legislature, the legislative intent is not involved in this, or not part of this record, to my understanding.
Well,
but
before you go on, and I apologize, it isn't unless you get to the impairment of contract argument. Because if you apply the Searcy test, then you're looking at what benefit the state got out of this versus the impairment on a contract. So at that point, you kind of get into what the legislature was doing, why they were creating this tuition differential fee.
Well, with respect to the impairment of contract, first, of course, you would have to find that there was an entitlement to the value of the TDF, the tuition differential fee, that was somehow contained in the definition of a tuition fee that was contained as a part of a registration fee when Mrs. Snyder bought her plan in January of 2004. First, you would have to find that, and that's a big stretch in terms of the definitions that have been provided to you by the legislature for tuition and tuition differential fee. If you pass that, then you would have to go to the Sarasegdeni test, talking about the balancing of the interest of the state with the supposed impaired contract right. Third, then, you still have to identify some law that the legislature enacted after Mrs. Snyder got the benefit or got the entitlement to this TDF, though it didn't exist at the time when she bought her contract in January of '04. If you find all those things, then you still have to have, well, then what law did the state enact that impaired the contract? You've got to have a law to impair a contract. Are you saying what law came around that meets that test of impairment of contract?
Tuition differential fee.
I'm sorry?
The law that they're challenging is, and you may not agree it's an impairment, but the law that they say impaired their contract was adoption of the tuition differential fee.
Respectfully, Your Honor, they're not, as I gather from their argument, they're not arguing against the tuition differential fee. They want this amorphous kind of value of the TDF, tuition differential fee, to take it out of Florida and apply it to the Citadel. So they're not really attacking the TDF. What they're attacking is somehow that the legislature can't create a TDF, as you say, tuition fee number 2, because that somehow is a device, a bait and switch, a scam for the legislature to avoid increased tuition.
If you bought this contract,
I'm sorry, sir?
if you bought this contract back in '03, would you not assume that tuition is going to rise with the cost of going, cost associated with going to college?
I think that's a fair assumption, that people believe that tuition would increase. Now, tuition has not increased according to the legislature.
Tuition has not been increased because they put it in tuition differential fee.
Right. But Your Honor,
So I'm just saying, and when you bought this contract, didn't you assume that tuition was going to rise? And okay, I'm willing to buy this contract because even though I'm being promised all this stuff in Florida, they put in there, I'm not saying it's not a good decision, but they put in there that I can use the value of that tuition fee, which I assume is going to rise, at another college.
What they said is you can transfer the redemption value of your plan in Florida to a qualified eligible institution, let's just say an out-of-state university. Transfer is a very important verb here. It's used in the contracts, both in the 03-04 contract as well as the 16-17 contract. It's used in the statute at paragraph 3, 1009.98.3, transfer of benefits to private and out-of-state colleges and universities and to career centers. So what transfer means is that you can only transfer from Florida what you got in Florida to what you got to North Carolina. What they're suggesting, what appellants are suggesting, is we want to create something in the process because, as Judge Thomas has noted, Mrs. Snyder's beneficiary doesn't pay the TDF in the state of Florida. Exactly.
But the person, if they had, they would get the value of the TDF as part of their contract because they've been exempted.
Well, if I could pare this down, correct me if I'm wrong, but I hear the appellant's argument to be you know, we entered into a contract in '03, but at the time my son went to college, I want to concentrate on the verbiage current rate. And so I want the benefit of the current rate, whether I contracted for it or not. And it wouldn't, if we accepted that interpretation, wouldn't we better get ready for a lot of lawsuits to come back in here and say, well, regardless of what I contracted for, I think my monetary transfer value is the current rate, inclusive of every fee and every bit of money that's charged by FSU or another university, and it doesn't matter what I contemplated being covered at the time I entered into a contract.
I believe you're right, Judge Thomas. What the appellants would have you do is basically say that there is no meaning in tuition other than it's some sort of all-encompassing concept that covers the cost of college. And as I've noted earlier here, in 1009.24, there are probably 20 fees that are identified, most of which aren't even subject to a Florida prepaid college plan, so that they could not have been accounted for anyway. But by your comments and by the appellant's position here, all of those could somehow be encompassed in the notion of tuition and therefore be payable under a plan.
Did the trial court specifically rule what was contemplated by the parties? As I read a lot of his order, there's no breach here because you have a right to amend whenever you want. That's mainly what the order seems to say to me. So he never really got to some of these other arguments about what was contemplated by the parties at the time they entered into the contract.
My recollection, Your Honor, is that Judge Cooper held that there was no breach. He specifically held, to your point, that the contract was subject to change in the administrative process. But I think finally he also ruled that even if the 03-04 contract applied, then his ruling would still hold, that there was no breach under that contract as well. And I've identified for you, Your Honor, the provision in the 03-04 contract that talked about, under the heading, additional fees. Now, once again, it comes to the point. The contract itself in 03-04 says, and this is...
But the examples of the fees they give there are fees that, to me, are not necessarily associated with the classroom. Athletic fee, parking fees. So reading that contract, couldn't I think, okay, yeah, they could do all these other fees that are not associated with sitting in the classroom, and I'd be responsible for that. Is that not a reasonable reading of
Respectfully, Your Honor, no.
Okay,
because
well, why not?
It says that provision, additional fees, says including but not limited to. And you would have to, I think, have a very aggressive kind of interpretation that a phrase like that somehow nonetheless limits a fee to one associated with sitting in the classroom. Now, of course, all I've heard from appellants is that the tuition differential fee is a fee that's associated with sitting in a classroom. So it seems to me, to take your argument, that the additional fee provision in the 03-04 contract contemplated an additional fee such as the TDF, that when Mrs. Snyder bought her plan in January of 04, she fully was placed on notice that her tuition plan was limited to the identified fees. In that case, it was 120 hours, credit hours of registration fees, tuition/matriculation, financial fee, capital improvement fee, and building fee. That's what she contracted for. That's what she got. That's what she has received. There has been no suggestion of waiver on the part of Prepaid with respect to Mrs. Snyder using that plan that she purchased in January of 04 for her son's attendance at the Citadel. So, Your Honor, there are so many ways to get to the conclusion that we believe that Judge Cooper correctly reached, which is that the tuition plan purchased by Mrs. Snyder in January of 2004 cannot be read either by contract as informed by statute, to include an entitlement to the redemption value of the TDF, the tuition differential fee, when in fact she is receiving as a transfer all that she would have received had her son gone to University of Florida, Florida State University.
I just keep on going back to, under your reading, tuition never has to be raised ever again. And isn't that taking away some contemplation of some value that was contemplated by the parties at the beginning, or arguably contemplated?
Your Honor, you would have to reach that kind of understanding, assumption, is to say that the TDF that was enacted into law in '07 is really a tuition under another name. And to do that, there is nothing in the record to support that. You would have to basically assume that you knew what the legislature was doing, and I think that's a bridge too far. And I'm willing to cede the remainder of my time, Your Honor, if there's no further questions.
Okay, you see the remainder of your time.
Thank you.
I'm going to try and knock these down in the remaining time if I can. Very briefly, on this issue of additional fees and the suggestion that we're going to have a parade of horribles and other lawsuits if Your Honor rules in favor of the plaintiff. 1009.2418 expressly states that a university cannot charge another fee unless it's authorized by the legislature in the section that we're referring to. The things that are included in there are, yes, tuition differential, financial aid fee, but the overwhelming majority of them, and I just circled a few for the court to see that we're not going to have any concerns about that. Fee for a diploma, fee for health charges, fee for supplies, fee for traffic and parking fees, fee for library fines. That isn't what, there shouldn't be any concern that if the court rules in favor of the appellant in this case, that there will be a flood of lawsuits saying that a library fine is tuition and everybody ought to have that covered by a prepaid contract. So I think that is a little bit of a red herring. But this is one of the things I'd like to focus on. In today's arguments, you have not heard word one about the power of the board to do what has just been suggested to you that it can do. And there is a statute that enumerates the powers of the board. It has not changed one lick from the time this first got started in 2002 when the planning and the authorization for this took place and today. And I would urge the court in response to some of the arguments that you just heard to take a look at 1009.9714F. And this is in the statute where it talks about the powers of the board. It has the power, it's a little bit long, but I'm going to paraphrase the first sentence, to make sure that the funds that are there to take care of the people who have contracts are financially sound and that they don't have concerns about that. And then it goes on in the last sentence. If the board perceives a need for additional assets in order to preserve actuarial soundness of the prepaid program, the board may adjust the terms of subsequent advance payment contracts to ensure such soundness. What they're doing in this case is taking the position that they can make those adjustments in response to legislative changes where the state, and the record is clear on this, it's trying to change the cost of going to college in Florida. We haven't talked much about today about whether or not parole evidence can be considered, but you just heard that there's no basis for us to assume that tuition differential, it has the word tuition in it, and tuition differential, that means the difference between something and something. And the representatives of the defendant in this case were screaming and yelling, if I can say that, at the time this legislation was contemplated because people wanted to raise the rates of tuition in Florida. And all of this, and I agree with Your Honor's suggestions, I'm not saying you made your mind up, but the idea that you can pretend like you're not raising tuition because you just slough it off onto something else that's called tuition differential One of the representatives of the board, a highly placed person, and I forget if it was the current or former chairman, called it something like a charade. And I don't want to impugn anybody by repeating that, but that is at least a powerful suggestion if the contract is ambiguous, particularly where they are claiming a power which statutorily it would seem that the legislature has denied to them. And in response to one of your other questions, Your Honor, you asked, well, what would happen if they just, stopped calling it tuition altogether? They put that down to zero, and they shifted it all off onto the tuition differential. And I don't know if you heard an answer to that. It doesn't frankly matter if it's called the pink elephant fee. In this particular case, the representative in the 1.310B6 deposition that was given took the position that if that happened, the board would transfer $0 out of state to the Citadel. That can't be what this contract stands for. And I would submit, if Your Honors do conclude that you should consider, and we believe you should, parole evidence, there is abundant evidence that what we bought, at least it was advertised. And by the way, under the powers of the board, they are obliged to approve every advertisement that goes out for board contracts. And what they advertised this was something of value. In recognition, or anticipation.
I keep on thinking that, I feel a little at loss here because there was really no factual findings as to what a tuition fee is.
Correct.
And I'm kind of, both sides are asking me to, I shouldn't say asking me, asking this court to, in the first instance, try to define that, take evidence. It's a little bit of an uncomfortable position.
No, if I may, Your Honor, no, we are not. What we asked for is a reversal of the judgment against us and a jury trial as to the intent of the parties. That is the way that these matters should be resolved. And I know, before I sit down, can I say two more things, Your Honor?
No, you just raised something that the scope, you think that a jury should decide this issue. And what specific factual issue? I mean, I alluded to something, but what specific factual issue, if we reverse the summary judgment here?
If, barring some other occurrence in discovery that's taken by the parties, a decision, and given the application of rules and jury instructions, we would submit things like contracts of adhesions, which would help guide the jury, rules of construction, which would be included in the jury instructions.
I understand the instructions you're giving, but what specific factual issues?
Whether or not one of the issues is what currently is represented as the tuition differential fee, assuming it doesn't change between now and the time of the trial, is something that is properly considered within the contemplation of the parties to be tuition in this case, because it is a fee, 70% paid for instruction, we know that, and 30% paid for financial aid. And we contracted for a financial aid fee under our registration fees. May I say those two things, Your Honor?
Okay.
One is, I don't know if this satisfies Your Honor, but one of the things Mr. Hoffman pointed out to me that we pled was to request umbrella relief, asking the court to grant such relief as the court deems appropriate. I don't know if that's broad enough for Your Honor to include some of the things you were considering. And then the last thing, because there was some discussion earlier, I think it was in response to a question of Judge Thomas's, about what it was that was contemplated. Didn't the state take care of these people? Please remember that in the record, and it's in our brief, OPAGA, when it recommended a workaround, the workaround that the legislature ultimately adopted, it specifically told everyone, but you're going to have to figure out a way to take care of the Snyders of the world. And that's something that nobody ever did. And that's what we're here for. We're here for those rights that have been taken away. Thank you, Your Honor.
Okay. I'm going to do something a little unusual here, and with my colleagues don't object. This whole issue of any factual issues remaining was something new that kind of popped up, and you had time remaining. I'm going to, if you would like, would you like to address that at all for 2 minutes?
I will accept the invitation, Your Honor. This is completely a matter of law. The legislature has defined tuition and defined the tuition differential fee. We at Prepaid issued a tuition plan that covers tuition and does not cover tuition differential fee. It's our position that there is no factual determination that needs to be made.
Okay, thank you.
Thank you, Your Honor.
Okay, there being no further cases in front of the court will stand at recess.
All rise.